Hello, and thank you for joining us today. My name is Yongki Hong. I'm a senior associate at Scar Legal PC. Today's webinar will focus on the L-1 and EB-1C visa options. We are very fortunate to have our firm's partner, Weiner, as the speaker for today's presentation. I will begin with an overview of general L1A requirements, and then Kelly will discuss more detailed practical guidance on both L1A visa and EB-1C green card process. Before we dive in, let me briefly introduce our firm and go over a few housekeeping items. We are a full-service immigration law firm, and we offer representation across a wide range of practice areas, including E2, O1, TN, L1, H1B, and all types of employment and family-based green card cases. That said, we are particularly well known for our work in the business and employment-based immigration cases, and we have built a strong reputation in those areas because we have processed thousands of these types of cases, including many highly complex matters, and have been able to secure approvals for the vast majority of them. At the end of this webinar, we'll send you several useful tools. A copy of a PowerPoint presentation we'll go through today, a link where you can download guidelines with more details on visa options, a link to sign up for additional webinars, a link to the webinar recording on YouTube. We definitely encourage you to subscribe and hit the notification button as we regularly post immigration related videos. And lastly, a link where you can set up a private consultation with us. Finally, for any questions, please type them into the chat box or Q&A box. We'll address all the questions at the end of the presentation. And with that, let's get started. So, what is L1 visa? It is often called intra-company transfer visa, and it is used to transfer qualified employees in executive, managerial, or special knowledge positions from company abroad to their U.S. parent, subsidiary, affiliate, or branch office. It is also used for a foreign national company who wants to open their new office in the United States and send their employees to their new US office. The definition of a new office is an office that has been operating or trading less than 1 year. So let's talk about some basic requirement for L1 visa. The major requirement is that there should be a qualifying relationship between the foreign company and US company. Only 4 types of relationships are qualified according to regulation. Is that parents, affiliate, branch, or subsidiary. This means that you have to really look at the company's ownership structure. And usually parents, branch, or subsidiary relationships are relatively easy to understand because it is a situation where either foreign company or US company owns the other one. However, the definition of affiliate can be a little confusing because we often receive questions about whether a joint venture relationship would qualify for this. Unfortunately, answer is no. A joint venture does not qualify under the definition of affiliate because it means the same individual or the same group of individuals owns the majority shares of both companies and has the power to control each of them. In joint venture relationships, it doesn't work that way because every each company has their own ownership structure and it's not overlapping. That's why it's not qualified. Next requirement is both companies are doing business on an ongoing basis defined as the regular, systematic, and continuous provision of goods and or services by a qualifying organization. This means the company needs to actually operate and generate incomes. If company just existing on the paper, but does not have any employees, showing zero incomes in tax returns, then unfortunately your company is not eligible for L-1 visa. But one exception is that if U.S. company is a startup, basically new office category, has been doing business for less than 1 year, it means your L-1 visa case will be categorized as a new office application and you may be still eligible for L1 even if the US company has not generated any incomes yet. But please keep in mind that there are a few additional requirements for L1 new office category. We'll get to that point later. Another requirement is the employee applicant should have already worked for the foreign national company for at least one continuous year out of past 3 years. And it cannot be just any employees. It has to be the one in manager or executive or specialized knowledge positions. L1A employee applicants US role also has to be same category, manager, executive, or special knowledge positions. USCIS use very specific definition of who qualifies for one of these categories. So L1A visa is particularly challenging in terms of the applicant's current job descriptions and proposed future job descriptions in the United States. For manager and executive, the visa category will be L1A, and you can renew it up to 7 years, and you will get 3 years first, and then will be able to renew it every 2 years. L1B category will be those employees who will apply based on their specialized knowledge. This case will be based on the employees specialized based on company's unique technology or service or products. You can also in L1A L1B case, and you can also open the new office and apply for it. In that case will be categorized L1B new office and can renew it only up to 5 years. But there's one thing about L1B, special thing about it is that you can recapture the times. For example, you need to spend a few weeks or a few months outside of the United States due to the job requirements. Then you may recapture these times to add more times when you submit your renewal application. Next. So what are the new office requirements? The new office is business entity which has been doing business in the United States for less than 1 year. If the company, US company, is categorized as a new office, then there are additional requirements, and let's look at those additional requirements. One requirement is that you need to submit proof the company has secured sufficient physical premises to house the new office. This means the USCIS want to see evidence that US company has a real physical office space, and that space is sufficient for the company's future hiring plans. I'll give you an example. For example, if your business plan states that US company will hire 10 employees within the next 2 years, then leased office space should be large enough to reasonably accommodate this much of expansion within 2 years. You could argue that you will start with a small 1 or 2 office space, very small space for the only 1 or 2 people, then we'll move to a bigger space when company expands in the future. But such argument has not been really well preferred by USCIS. So it is very critical that for L1A or L1B new office spaces, you need to actually secure more traditional and private office space rather than a simple co-working or shared workspace. Another requirement is that employee must have been executive or manager for 1 continuous year out of 3 years preceding petition and proposed employment in the United States. So the U.S. company does not need to have an employee before applying L1A U office. However, you must show that the intended U.S. operation will support an executive or manager position within 1 year of approval. So USCIS will want to see information related to scope of office, organizational structure, and financial goals, size of U.S. investment, and financial ability of a foreign company to pay employee and start a business in the United States, and organizational structure of a foreign company. So in the new office category, at the end of the first year, you should be able to show that the U.S. company has hired enough number of people so that the executive or manager position foreign national employees only focusing on what they are supposed to do, not really doing like administrative works or not doing any kind of actual sales. For example, you are CEO, a beneficiary is a CEO, and you only hire the receptionist after 1 year. Then USCIS will assume that you are still doing all kinds of actual work, such as sales, marketing, things that usually not within general definition of executive job duties. That's why it is very important that L1A, B new office categories need to hire enough number of US workers at the end of 1 year. So L1B new office is for someone who comes to United States with a very specialized knowledge on the company's product or service. A good example would be an engineer who invented a brilliant technology and even has a patent with his name on it. And he's coming to the United States' new office to set up the company's operating systems before he actually start operating and generate incomes. Like L1A new office category, it also requires a physical office space. It also needs to show that the company has a financial ability to pay the employee and commence doing business in the United States. For this category, USCIS a little more focuses on whether the company has a realistically support the specialized employee for next 1 year. Because the company is not really actually operating yet, they are more curious to know they have a financial ability to support these specialized employees next 1 year employment. Particularly, they look at whether the employee will be able to apply his or her special knowledge to actually launch the business in the United States, whether the company has sufficient operating fund to support that kind of work for next 1 year, and whether there are enough financial and operational resources to establish the initial technologies, systems, or process that employees expected to set up. Okay, so that's general rules about L1A and L1A new office category. With that in mind, let me turn it over Kelly, who will guide you through the next part of our presentation.
Thank you, Yongki. Perfect. So we're going to go a little bit more in detail now, just to talk about, what is an executive, manager, specialized knowledge worker? What do these terms mean? And, how do you present an L1 petition? And also talk about EB-1C later in the slides. So just starting off with what is the definition, of an executive? As you can see here, it is, specified in the regulations, right? So an executive capacity means someone who is directing the management of an organization or a major component or function, establishes goals and policies, exercises wide latitude and discretionary decision making, receives only general supervision or directive from high-level executives, boards of directors, or stockholders. And the way that the government kind of interprets these, kind of criteria is relatively strict. They really will kind of pick at the job duty description, for any of these categories to see does it really fit within these criteria. And so sometimes the challenge can be, particularly if it's kind of a smaller company, right? Like, does someone really qualify as an executive if they only have a couple employees? Who is doing the operational work? And for the L1, one of the challenges can be that they really don't want the executive doing anything that is kind of, non-executive duties. The duties primarily do need to be executive duties. They can't be split between kind of half manager, half executive. You have to pick a category and kind of, support that. Um, Another thing to consider here, they talk about, directing the management of an organization. That generally means there should be a management to direct. So again, thinking about kind of what is the hierarchy of the company, who's going to be hired. If you're doing a new office, you do get that 1 year runway to kind of build out the office to, the size that it would support an executive role. But when you're thinking about what is the job description, for this executive, you really do need to kind of start with these criteria and make sure that what you're discussing, kind of aligns with this. And if you want to argue they're an executive. So let's move to the next slide. All right. So what is the definition of managerial capacity? So similar to kind of the executive, there's kind of a list of criteria, and the government is quite strict about how they will view these. So a manager, manages an organization, department, subdivision, function, or component of an organization. If they are a personnel manager, they're going to supervise and control the work of other supervisory, professional, or managerial employees. Another type of manager you can have besides a personnel manager is a function manager. So you can try to argue, like, let's say somebody doesn't manage a lot of, direct employees, but they are responsible for kind of managing a specific function within the organization. So just because it's set up in such a way that they do not have direct reports, if there's kind of indirect reports they have that are doing the actual operational work and they sit more in a managerial role overseeing the function, that's another argument that you can make. Again, if it's a personnel manager, you show they have the authority to hire and fire and recommend personnel actions like promotion, leave, authorization. Um, if there's no employees that are being supervised and it's a function manager argument, you need to show that they operate at a senior level within the organizational hierarchy. So usually you're going to show this by showing kind of who they confer with, who they report to, when they manage their function. Are they kind of the last say on many important things, or are they constantly having to, align with others? And then also showing they exercise discretion over the day-to-day operations of the activity or the function. So, if you have a manager and they're just supervising kind of, frontline employees who are not professional roles, are not supervisors themselves, this can be a much harder argument to make, for a manager. Additionally, if you have somebody and you want to qualify, they're not an executive, they're not a specialist, you want to qualify them as a manager, but they don't manage a lot of people. Important to think about, do you have a function manager argument? And there's some extra things you have to prove here. Is the function kind of critical or essential? to the organization. So you have to define what is the function, and then kind of go through and demonstrate that the person operates at this senior level, for the function, that they have discretion over how the function is managed, and that they are managing the function, not performing it. And that can be a very nuanced line to have to draw, so that, in any L1A, or L1B application, you are having to really spend some time. You can't just kind of take the stock job description and submit that. You really need to be thinking about, what is this person doing and how does this align with the criteria the government has set out for what they consider to be a manager. Perfect. We can move to the next slide, which is specialized knowledge. So, for this type of category, it's an L1B visa. Some important distinctions that Yongki had gone over previously. Specialized knowledge means special knowledge possessed by the individual of the organization's product, service, research, equipment, techniques, management, or other interests, or an advanced level of knowledge or expertise in the organization's processes and procedures. With either, generally the petitioner has to demonstrate this isn't knowledge commonly held throughout the industry. So it's a quite difficult standard to meet. It's very complex. If there's as Yongki mentioned, if there's a proprietary product, if you have an engineer who's developed something, very specific, and they're coming to implement that, and it's, they're the only one that knows how to do it, then that may be kind of a more straightforward case. But a lot of, for these types of cases, the challenge can be that not only does this person have to have this specialized knowledge, but you also have to find a way to demonstrate that this is not commonly held throughout the industry, that it wouldn't be easy. Why couldn't the employer kind of just hire in the open market for this, for this role? What is it in particular that the person knows? What is the special knowledge that they have? And just kind of making sure that you're building a narrative that makes sense. So you really do often have to, think about, what is the company doing, and, dig into the details of what this person is doing and what their specific expertise is, in order to explain it in layman's terms, to the officer, so that they are convinced that this person really does have this specialized knowledge that's, particularly important to the employer's kind of competition in the industry, or kind of knows things, that others don't know. With advanced knowledge, sometimes this can be a helpful one if you have an employee who maybe doesn't have a very long work history, but perhaps was kind of with a startup from, the minute that it started, and has a real intricate knowledge of kind of the processes and procedures of the company, or was very influential in how the company kind of set up certain things that are now extremely important to transfer to the US office. So you do have to kind of be, I think, sometimes creative with these, specialized knowledge petitions, but you also want to think, if you're trying to transfer somebody, and, you want to use this category, you really need to dig into their resume, into their capabilities, into their skill sets, and be honest about whether or not, this is somebody who will meet this criteria, since it is quite, difficult to meet. All right, moving to kind of some more practical considerations, what documents need to be submitted. An L petition is going to be filed with U.S. Citizenship and Immigration Services first. So even if the person's outside the country, you're not going to go directly to a consulate. First, you need to get an approval from U.S. Citizenship and Immigration Services. You file this on Form I-129. So you're going to provide documentation showing that the petitioner and the beneficiary meet each of the L requirements. So corporate documents showing there's that qualifying relationship between the companies, proof that each company is doing business, things like tax returns, financial statements, commercial lease agreements, payroll summaries, W-2s, invoices, or proof of sales. Then you move to kind of the employee requirement. So proof that the employee has worked for the company abroad for one continuous year out of the past 3 years in a managerial, executive, or specialized knowledge role. Part of this will be just the pay statements, showing the 12 months or more of employment. You'll also want to include a very detailed job description. And as I mentioned previously, this isn't going to be just, well, this is what we advertise for this job as. Generally, you're really going to want to craft this statement with the attorneys to understand how you can align it with the regulatory requirements. An organizational chart showing the employee hierarchy. This is going to be very important. particularly for managerial and executive roles, but can also be important for a specialized knowledge role. Sometimes you're going to include work product, for example, in specialized knowledge. This can be, particularly helpful to demonstrate, something that the employee has done, and kind of explaining the context. Can also be relevant for proving things like a manager or an executive, for example, redacted, emails showing kind of leave authorizations or promotions for a manager, or showing kind of goals or policy setting, maybe for an executive. Uh, and then you have to include proof that the employee's role in the US is going to qualify as managerial, executive, or specialized knowledge. And you're going to include similar kind of documentation for that. Also, an important thing to note is that the roles do not have to be the same. So, for example, if somebody is a senior manager, at the company and is now being promoted to an executive role in the United States, that's fine. But again, you have to make that really, really clear. How are they qualifying both for the role abroad and the role in the United States, knowing that they're not going to be the same. And if they aren't the same, you also need to be thinking about proving that the person has the skills and capability to hold that role in the United States. So it can be a more straightforward application if the roles are the same. Someone is a VP of finance and is being transferred to the United States to be a VP of finance. But also important to note that it does not need to be a transfer of the same role. But if it's not going to be a transfer of the same role, you need to include an explanation of why this person is qualified for the role they're being transferred or promoted into. Okay, so what do you need for a request for evidence? So unfortunately, requests for evidence are relatively common for L-1 petitions. Rates have dropped, did drop between, 2022 and 2024. We do anticipate kind of a bit more of an uptick, in the coming years. And, in 2019 to 2021, for example, RFE rates were over 50%. So there is a lot of scrutiny on these applications, particularly L-1B applications. But kind of across the board, new office applications are also scrutinized very closely. Most requests for evidence, even if they have kind of other inquiries in them, almost all of them will also include a challenge to whether the applicant meets this definition of manager, executive, or specialized knowledge worker. Again, I've mentioned this previously, but they're just very rigid about how they view this. If they feel that an executive is doing too much operational work or too much frontline sales, that's going to be problematic for them. So you want to think about how to position it, to explain that this person really is doing executive level duties that align with, the regulatory criteria. So when you do get challenged on this, detailed support letters and organizational charts, often that contain maybe more detail than in the initial submission about each employee operating under, the executive or manager, what their degrees are, what their salaries are, what their job duties are. But although these are helpful, you always in an RFE want to supplement this with objective evidence. You don't want to give the government an ability to say, well, you've just written a lot of letters. How are we to know that this is actually correct? So always good in a request for evidence to submit with, things like work product, with context, things like emails. Let's say an executive or manager has created a policy handbook that is now, governing the entire company. And there's, evidence that this was done. Performance reviews. Let's say that a manager is conducting performance reviews for their team, that kind of gives this background and detail on what their authority is. So you always want to make sure in a request for evidence to be, give detailed examples and provide kind of objective work product, that was kind of put in place before you filed the petition to help support what you're arguing, right? So you wouldn't say, oh, well, this manager kind of, is the person who has the authority to set the client targets, for 2025. You'd want to provide kind of the email exchange or, kind of the internal meeting notes, with others involved and explain who they are, showing that the manager had this authority. So that type of detail and kind of objective evidence to back up, your other supporting letters and charts is very important for a request for evidence. All right, let's talk a little bit about timing and also kind of dependence. So in terms of how the process works, the L petition first has to be approved by USCIS. Normal processing times are kind of several months, maybe even up to a year. There is an option, though, to pay for an additional fee for premium processing to get a response within 15 business days. This response can be an approval, a denial, or a request for evidence or a notice of intent to deny the petition. If it's a request for evidence or notice of intent to deny, you would prepare, responsive documents, submit them, and then generally they will issue a final decision within 15 business days after that, if you've paid for premium processing. Sometimes, like very, very rarely, they will issue a second request for evidence. That's a very, very rare outlier situation, but every now and then it does happen. So just making you aware it's possible. After the petition is approved, assuming you get an approval from USCIS, if the employee is outside the United States and this was filed, for a consular notification, then the employee is going to take that approval notice, file a DS-160 application and go to a US consulate to get an L-1 visa stamp. Canadians who are visa exempt can kind of take that approval notice and go to the border and just get a stamp, a written stamp in their passport. Additionally, if you're inside the United States, like let's say you came on a B-1, for a business trip, and for some reason you filed for a change of status, then the change of status can, you can stay in the United States, and then when you're ready to travel, you can go to a consulate and use that approved change of status to get a visa stamp in your passport. Um, Spouses and unmarried children under 21 can accompany on L2 dependent visas. The spouses can work, so they can work just incident to their status as an L2 spouse. When you enter the United States, they should make sure their I-94 is annotated L2S as an L2 spouse, and this can be used as proof of work authorization. Children can attend school on the L2, but cannot work. All right, let's turn a little bit and talk about the EB-1C and kind of does an L-1 visa lead to a green card? So, for people who are kind of coming on the L-1A, they often will, want to transition to a green card on the EB-1C. The EB-1C is a multinational manager or executive green card. It has very similar requirements to the L-1A. So the same requirements about having a qualifying relationship between the company abroad and the US. Companies must both be doing business. One difference between that and the L-1A is for the EB-1C, the business in the US has to have been doing business actively for at least a year. For the L, if it hasn't, you can still get a new office temporary visa. That's not the case for the EB-1C. So if you've entered, for example, as an L-1A for a new office, you can't immediately file your EB-1C application. You would have to, wait until the company had been operating for at least a year. You have to show, similarly, that the employees worked in an executive or managerial role for at least one continuous year in the last 3 years. If the petitioner is in the U.S., they will adjust that date, as to when they entered the U.S. on the work visa for the petitioning company. Big benefit, of the EB-1C is that there's no labor certification. The labor certification process is one where a U.S. employer who wants to sponsor a foreign worker has to actually test the U.S. labor market to see if there's willing, qualified, and available U.S. workers. This is a process which in itself can take a few years. So a benefit of the EB-1C is that you can go ahead and just file your I-140 petition. You don't have to do this labor market test that can take a couple years. And the EB-1 category is, often current worldwide, even though it may be backlogged for certain countries. So the EB-1C can be a great, option if you're on an L-1A, assuming you were a manager or executive in your role before you came to the United States. So I think that's an important thing to flag because sometimes someone may have been in, for example, a specialized knowledge role and they were promoted into an executive or managerial role in the United States. In that instance, that person will not be eligible for an EB-1C because their role abroad was not a managerial or executive role. So if somebody is targeting an EB-1C and you're working, you're doing an L-1A process for them, it's important to see, can the job that was abroad be classified as managerial or executive? Because if it's not, if the person was not considered a manager or executive, they're not going to be able to go through the EB-1C process. Additionally, important to keep in mind that just because you were approved for an L-1A does not mean you will automatically be approved for an EB-1C. The EB-1C is a green card, allows you to live and work in the United States permanently, and they kind of will apply a heightened standard to it. So if you got an L-1A, but it was a big fight, it was really, really difficult, you got a very aggressive RFE, and it ultimately was approved, like the EB-1C may be quite difficult. And one challenge that can also happen is that if your time as a manager or executive abroad, like if that's really what was the challenging part, either it was a very small company or the company wasn't doing well, you weren't managing that many people. That's not something that you can kind of fix down the road for the EB-1C, right? So when they do the EB-1C, they'll be looking back at when you were working abroad. What was the size of your team? Do you meet the executive or managerial criteria? And if you did so for the L-1A, but it was very difficult to prove that you did so, that could be an indication that, it's setting you up for a more difficult, kind of EB-1C process. So good to think about kind of what are your long-term goals when developing the L-1A. For L-1B, they don't have the option to go through the EB-1C. If somebody on an L-1B wants to have a green card, there may be other options, but one potential option for them would be the PERM process. This would be the normal process where a U.S. employer is going to sponsor, the foreign worker, and they're going to test the labor market for willing, qualified, and available U.S. workers. If there are none available, then they can obtain the labor certification and then process the green card under the EB2 or EB3 categories. This can be sometimes a less attractive option just because there is kind of a worldwide backlog and then longer country-specific backlogs for EB2 and EB3. And then, of course, you have to actually go through the labor certification, which is, a couple of year process. We do have another webinar that goes more in depth over kind of the PERM process, the labor certification. But for today, we will kind of leave it there. One other thing I want to mention about the EB-1C is just that there's an ability to get that first step approved through premium processing, where you can pay an additional fee, and get an answer, within 45 business days. So that can be a good option as well for people who are interested in the green card and interested in doing it in a faster period in time. That being said, you do have to consider, what is the strength of your case? What was the, how easily or not easily was the L approved? Because that will be relevant to, whether your EB-1C kind of can go through easily or not. Perfect. So I think we've reached the end of the presentation.
Okay, thank you, Kelly. That was really helpful and informative. With that, let's go ahead and take a look at questions. We don't have any questions. That's fine.
Perfect.
Yeah,
I
in the
think we can
case,
close here.
yeah, thank you for joining us today. We hope this webinar has been very helpful and informative for you. If you have any additional questions, please feel free to visit our website and schedule a consultation with our team. We look forward to seeing you at our next webinar. Thank you.
Thank you.